want to turn now to Massachusetts for the dismembered murdered wife case of Brian Walsh. Now, he was back in court this week for a pretrial hearing. Now, Walsh is accused of killing his wife, Ana, on January 1st of 2023. Her body has never been found. Now, prosecutors allege that he killed her after finding out that she was having an affair. Now, during the hearing this week, the defense argued to have the first-degree murder charge against Walsh dismissed, claiming there is no evidence of premeditation to support the prosecutor's claims. And we're bringing you that hearing now. We begin with the defense attorney, Larry Tipton.
I know the government wants, and they've said it to the public, but they're just wrong. Mr. Walsh did not know about an affair, period. What AK, and I'll just use the initials that I did in the memo, what AK told the grand jury was that Ana Walshe had talked about telling Mr. Walsh she had a crush on someone. There was no testimony by AK that Ana Walshe discussed with her that Mr. Walsh knew about the affair. It was ongoing.
I don't think that's correct, counsel.
Okay.
Let me tell you what I have in mind from reading. I just need to find the right piece of paper, but I will. AK testified that the defendant told Ana that his mother had told him that Ana was going to leave him for a guy in D.C. and take the kids, and that he believed that. That was her testimony.
I'm trying to think of that specific, I recall that specific testimony, but I don't think, I thought it said that, well.
59 to 60 of the transcript.
All right, can you pull that up?
Your Honor, do you have a date from that grand jury?
March 8th, 2023.
Thank you.
The defendant told the police in his January 4th interview that he had access to Ana's iMessenger on his phone and some access to her Instagram. Those are the two ways that Ana communicated with WF per his testimony. Also before the grand jury was that he, the defendant, searched WF's name 6 times on December 25th, 2022. That there were 20-something, 21, 25 searches between the 26th and January 1st on his Instagram account. They don't know where they were, too. Also before them were the messages between WF and Ana, which leave little doubt that there was an affair going on.
If I may inquire, Judge.
I've got to assess the evidence that was before the grand jury in its entirety. And that was the entirety of the evidence that was before them with regard to whether there was an affair going on and whether he knew about it, right?
Well, that's not the entirety. I'm sorry, Judge. I don't.
Well, that's some of it.
That's some of it. It's not the entirety, though, because the entirety also includes the testimony of the other testimony of AK and the other testimony of WF. And that testimony from WF was specific that him and WF and Ana were talking about their affair and that she wanted to tell Mr. Walsh about it, that she would, quote, be devastated if he learned about it. And then there's this conversation about his mother hiring the psychic and that's where that came from, hiring a psychic that told her, the mother, that Ana Walsh may leave the defendant for someone in D.C. And then WF is asked specifically by the government, was there any conversation about Mr. Walsh knowing, I'm going to paraphrase, knowing about the affair? No. Was there any conversation about whether she had told him about the affair? She wanted to tell him about the affair at some point.
That evidence go to the issue of whether or not Ana knew that Brian knew about the affair, not whether Brian knew about the affair.
Well, when the court recites the fact that if we assume for purposes of this motion that Mr. Walsh is the one that reached out and tried to search for WF, how does that show, how does that demonstrate reasonable and trustworthy and reliable facts, articulable facts, that he knew about, quote, an affair, as opposed to the simple truth that was presented to the grand jury that she had a crush on?
Well, let's put aside the searches on the searches on the December 25th. Put aside the 21 other searches between those dates, and just focus on his admission to the police on the 4th of his access to her Instagram and to her iMessenger and WF's exhibits of the messages between Ana and himself. As I said, there's little doubt, based on what's in there, you know what's in there, that there was an affair going on, right?
And you're referencing the messaging between Ana and WF.
Correct, which the defendant told the police on the 4th of January that he had access to that during his interview.
He may
That
have
was before the grand jury too.
He may have told, he in fact told the police that, yes, he had access to it. He never told the police that he read those text messages. He saw those text messages.
Isn't that a reasonable inference?
Why would it be? Why would it be a reasonable inference that jumps from the fact that someone may in fact be able to access messaging, but there is no, that he has access to it, but that in fact he did? Why is that?
I don't think that was his, I don't think that's his language on 1-4, but that he had access to it. It sounded, I'll go back and listen to it again, but my memory of it was that they were coming up on his phone.
Okay.
But I'll go back and refresh that. But what did you want to, so this idea, this notion that that there's no evidence supporting the fact that he knew of the affair just doesn't seem to me to be a fair assessment of the evidence that was before the grand jury.
Let's bring back in our guest still with us to discuss, criminal defense attorney and former assistant prosecutor Franz Borghardt. All right, Franz, here's where we are. The defense is essentially arguing that this first-degree murder charge shouldn't go forward. Of course, that requires some sort of premeditation. The way they're getting there is they're saying that he knew about this affair that Ana was having with this other guy, and they're kind of getting there with these inferences about what information he knew, what information he had heard about, what he had access to, but nothing concrete. So he's saying, look, that evidence wasn't in front of this grand jury. They should not have indicted on that charge. What do you make of his arguments?
So the viewers need to understand that in a death penalty case, you exhaust every single method of getting the death penalty off the table. And I think that this is a good example of a motion that, look, if they win the motion, death penalty's off the table. This is Florida. It'll be off the table. If they lose the motion, they've protected the record. But the bigger piece for me, Michael, is I'm listening. I don't have a dog in this hunt, but I'm listening and I'm thinking, well, if he knew about the affair and he acted because of the affair, that doesn't give him a free pass to murder. But doesn't that seem like a mitigator to to putting him to death? I mean, in some places, again, premeditation is not the same thing as manslaughter, but in some places, you know, the classic example of manslaughter is catching your partner doing something and in the heat of the moment, killing them because of that. So again, not a free pass to murder, but certainly is an interesting mitigator. And that's what keeps coming to me. And if I'm thinking that, does a potential juror think that? I don't know that they're going to have a chance at this motion, Michael, but it certainly is getting some of that argument out. And if I'm a prosecutor, I'm wondering that myself.
Well, it changes a little bit. I understand what you're saying, this heat of passion thing, as far as manslaughter and being mitigating. But what they're saying is that, let's say around December 22nd, he does a number of searches for the guy that they find out is her lover. And there's all these messages on Instagram. He admits to having access to iMessages and Instagram where the two of them were communicating. So from December 22nd all the way through January 1st, when they're claiming he killed her, he's thinking about this guy. He's stewing on this whole thing. He doesn't want her to leave. She tells him, I'm going to go to Washington with the kids because I'm working there almost full time at this point. And these are the things that lead him to say, you know what, I'm going to kill my wife and premeditate it. I'm not sure I see where you're going with the mitigating factor and the manslaughter aspect of it.
So I don't think it's manslaughter. I absolutely think it's murder. Now, whether or not it's murder such that you should put him to death or not, that's going to be up for a jury to decide. And oftentimes, and look, Michael, you know me well enough to know that I don't always make great arguments. I mean, that's common for me. But if you're deciding whether or not you're going to pursue this premeditation first-degree murder such that you're going to ask a jury to put him to death, because that's really the only benefit to it being first-degree murder in that state is death penalty. The jury will get to decide whether or not to put him to death or not. I think the mitigation piece for me, what I'm hearing is, you know, a normal, ordinary person that otherwise hasn't committed capital murder before, all of a sudden is percolating because maybe his loved one is committing adultery on him. Maybe that's some kind of mitigator. Maybe it's not. Maybe that's a good reason to put him to death.
Yeah, you make a good point, because at the end of the day, when you represent someone in a death penalty case, your mind is always at least partly on that penalty phase, right? So that's partly what you're saying here. All right, Franz, stand by. I want to step aside here, take a break. When we come back, the defense continues to counter claims that Walsh knew that his wife was having an affair, and it was a partial victory for convicted murderer Shonda Vander Ark in the tortured son murder case. But the win may not have been the one that she wanted. Details, Court TV Live returns. Welcome back to Court TV Live. I'm Michael Ayala. We do want to get you back to that motion hearing in the dismembered wife murder case of Brian Walsh going on in Massachusetts. He's scheduled to go on trial in October for allegedly killing and dismembering his wife, Ana, back in January of 2023, but her remains still have not been found. Prosecutors claim that he did it because she was having an affair. Now, that claim of premeditation is what had attorneys on both sides in court yesterday, as the defense tried to get the first-degree murder charge against Walsh dismissed by saying not enough evidence was in front of the grand jury to put him in, to go to trial on that case. All right, let's listen in on more of the defense attorney's argument.
He consistently, throughout his interviews, as I know them, with the police, averred that he wasn't having an affair, and he didn't believe she was either.
So turning back to that now, Judge, line 11 at page 60. Anna can believe what she wants to believe. There is no factual basis presented to the grand jury that Brian Walsh did, in fact, believe that. In fact, the evidence presented
believe what?
That she was having an affair. In fact, there's testimony at the grand jury that this psychic investigation was revealed by Brian to Ana Walsh. So how is it then that when people are sharing information and nothing happens at that time, nothing untoward at all happens at that time, that the government can then move on and pile another inference on top of that inference and say, therefore, Brian Walsh believed there was an affair, and therefore Brian Walsh acted on that belief, and therefore there's evidence of premeditation as opposed to motive or whatever. But how can a grand jury be permitted to pile inference on inference when that's what the government is at, if in fact that's what the government intends? That's what occurred. There is no trustworthy, reliable information that Brian Walsh believed or knew about an affair. And when you consider the testimony of WF at the grand jury and the testimony in conjunction with AK, did she ever say he was jealous?
Counsel, let's circle back to those December 25th, 2022, the 6 searches with regard to William Fasto on that day. So there are 6 searches that are done on a device that's attributed to Mr. Walsh for Mr. Fasto's name on December 25th.
Yes.
I think it's just randomly searching the guy's name on December 25th, the day that his wife is supposed to be coming home and missed her flight.
Well, he's trying to find out where she is because she's late, and she has to leave on the 25th, and she misses the flight, and she has to drive up.
And she thinks of William Fasto, or he thinks of William Fasto.
Well, he's also reaching out to others, I believe.
He didn't, as far as I know, the only information before the court from the materials that were in the grand jury is he searches William Fasto's name 6 times that day.
Okay, but William, she's already, if you believe what was presented to the grand jury, and that's the constraint we're under right now.
Sure.
She, according to AK, she told Mr. Walsh she had a crush on WF. So why wouldn't he, if your spouse says, I have a crush on this person, the other spouse is not allowed just to say, I want to learn about what that other person is.
When does, and this is up for grabs for either side, I have a question with regard to the evidence that was before the grand jury.
Folks, we're going to step aside here, but before we take a break, I do need to update you on 3 other big cases that Court TV is tracking. In Washington State, closing arguments are scheduled for Monday in the attempted honor-killing trial of Ihsan and Zara Ali. Now, they're accused of trying to choke their 17-year-old daughter to death outside her former high school last October. The jury will weigh charges of second-degree attempted murder and first-degree and second-degree assault. In Florida, jury deliberations are currently underway in the penalty phase of the in-law massacre case against Shelby Neely. Now, they've been deliberating for just under an hour. Now, this is a life or death decision. The jury must decide if he should get life or the death penalty for killing his wife's parents and her brother back in 2018. Now, he admitted to killing them after they became suspicious of what happened to their daughter, Jamie, who was killed months earlier. Also in Florida, the woman who was convicted in the tortured son murder trial wants a new trial. Shanda Vander Ark is serving a life sentence without parole for the death of her son, Timothy Ferguson. Vander Ark claims that she had ineffective assistance of counsel and was mentally incompetent to continue her trial. Now, during a hearing today, both sides argued their cases before the judge.
Giving her first day of testimony, she had a medical issue. She was in some sort of distress. Coming back the next day, it seemed pretty, from the transcript at least, that she had undergone a significant downturn in her mental health. That it was described by her trial counsel that she was not competent to go forward. And the bottom line is, well, was there a bona fide doubt as to her competence? And if there was, then the way to go about things is suspend the trial, have her checked out, and then if there is no longer an issue there, then proceed with the trial.
This was a feigned bout of incompetence to harbor an appellate parachute to undermine a jury verdict. And I think the court also is well aware that Ms. Vander Ark is a trained individual who might not be an attorney, but she went to law school, and by her own account, she was very smart, passed the bar, has all sorts of knowledge on certain things that she could do to undermine a jury verdict in this case.
Now, the judge denied Van der Ark's request for a new trial, but is allowing her a chance to make her case on other grounds, the ineffective assistance of counsel. Now, before we go back to court, we do have a quick programming note. After an emotional week in Idaho for Brian Kohlberger's sentencing, Shannon Gray, who delivered a victim impact statement on behalf of the Gonsalves family, is going to join Vinnie Politan Investigates tonight. Hear about his experience coming face to face with that quadruple murderer. All right, and it's an interview that you do not want to miss. Check it out tonight on Vinnie Politan Investigates, starting at 9 Eastern, right here on Court TV. All right, we'll take that break now. Up next, we have more in the pretrial hearing for Brian Walsh in the dismembered wife murder trial. The defense addresses claims that Walsh's marriage was in trouble. So keep it here on Court TV, your front row seat to justice.
Tonight on Closing Arguments, Shonda Van der Ark coming back to court asking for a new trial in the torture and murder of her son with special needs. We're live with key takeaways from today's hearing.
Closing Arguments tonight at 8, 7 Central, only on Court TV.
I want to get you back now to that pretrial hearing in the dismembered wife murder case in Massachusetts. Now, the attorney for defendant Brian Walsh is fighting to get that first-degree murder charge against him dismissed ahead of his October trial date. Let's listen in to more of the arguments.
It's clear that there was sufficient evidence before the grand jury that this marriage was in distress over the issues relating to his then pending federal sentence and the implications of that on their life and where the children lived. It was clear that AK was seeing something different than she had ever seen before in her friend, in her demeanor. She mentions that in her, which a reasonable inference could be based on the context of that, which was she was talking about her marriage and the failings of her marriage, that their marriage was under stress. So while I credit you that this notion that he planned this by ordering or by inviting Jem over, there doesn't seem to be any evidence before the grand jury that I can see. They'll argue otherwise, perhaps.
And let me respond to some of that, though, Judge, some of the themes of what you just said. Once again, I'm going to very quickly refer to AK's testimony. Yes, friends with Ana Walshe, recited conversations with Ana Walshe, was asked specifically, did she ever talk about divorce? No. No. What did she talk about? She talked about the frustration of not having the 3 kids in D.C. and the time it was taking. And who was Ana Walshe angry with? She was upset with Brian, but she was angry at his lawyer because she thought the lawyer was the one setting up this idea that the kids had to, the 3 children had to stay in Cohasset. That wasn't Brian's doing. The government tries to argue that, but that's not what the grand jury heard. Also, AK testifies initially.
But what the grand jury heard is she was angry with him because she had learned that it was not the FBI, but rather Brian himself that was delaying his sentence. The sentence, delaying the trial. Or the resolution of that case.
And she goes on to, I understand, she goes on to testify that Ana Walshe then was talking about Mr. Walsh, Brian, had to take responsibility and that they needed to work through this, and that's exactly what they were doing. To suggest that stressors, serious stressors, that have been going on for some time, somehow transform into motive to kill, malice, or premeditation is once again an inference that is not supported. It is, somebody can dream up the inference like the government is doing here, but it doesn't rest on the facts, and it doesn't rest on the entirety of the testimony of of AK. The same thing with the WF testimony. you know, if what the grand jury heard was, yes, there was conversations, but there was never the only conversation that he recalled where divorce was mentioned was in terms of, quote, protecting assets. And I will just, that's it. That's all he recalled. And when the assets may have been the life insurance. It might have been the value of the condominium, $1.3 million. It might have been the other properties they owned. They were renting the Cohasset property, but maybe the other properties. But here is WF being asked a myriad of questions about, well, didn't she talk about this? Didn't she talk about that? No. She always, quote, I'm not quoting, paraphrasing. WF said that what Ana Walshe described Brian was basically this wonderful man. That doesn't sound like, and it can't be used to now construct some argument that whatever stressors were going on in the family then can be used to establish premeditation or malice in any of its forms. It is, as we say, it is piling inference on inference, and doing so is violation of due process in Article 12 because the grand jury wasn't presented that type of evidence. It is the inferences that are being constructed by the Commonwealth that aren't grounded in articulable facts, plain and simple. The other thing is about the money. They'd already started paying the money back. This idea constructed out of whole cloth that somehow one of his motives was to murder his wife so he gets access to monies so he can pay $450,000 that they'd already started paying for, and they had all these properties, just defies logic.
Let's bring back in criminal defense attorney Franz Borghardt. And Franz, you know, this defense attorney, he's doing, a yeoman's job. I think he's doing a great job making the arguments, but he's got a tough road to hoe here because at the end of the day, there are a limit to the amount of inferences that can be made in a case like this, but when there are inferences in a case like this and we're at this stage, number one, the judge really wants to defer to the grand jury. Number two, she has to resolve all those inferences in favor of the prosecution. She's kind of been telling him that.
So two big problems for the defense. One, grand jury is a lower bar. It's probable cause, not proof beyond a reasonable doubt. And look, at the end of the day, problem number two is grand jurors and jurors can draw inferences through direct and indirect evidence. We let juries do it all the time, Michael. So the problem for the defense is I think at the end of this hearing, the judge is going to say, it's not clear cut that he did not have premeditation, and it's an issue for the trier of fact, the jury. It's kind of like watching a motion for summary judgment hearing, Michael, where one side's saying, oh, there's no material issue of fact, but there is a material issue of fact. And look, he's making great arguments for a closing argument.
Yes,
he's making great arguments for why there might not be premeditation for a jury, a pettit jury, but not necessarily for this pretrial motion, and certainly not enough to get death penalty off the table.
Yeah, that's what I was going to say. The good news is he's got some stuff to work with in this trial. It sounds like certainly good arguments for a closing argument, something you could argue to this jury. And again, I think the judge makes the point that the arguments that he's making are really about perhaps limiting what the prosecution can argue at this point, because maybe there's not enough evidence to argue X, Y, or Z. But at the end of the day, this stuff feels like it needs to go to the jury. Here's what I wanted to ask you about the sort of nature of this hearing. Sometimes in these hearings, I'm sure you've been to many of them, you can do it where the defense gets to make its argument, the state gets to make its argument. Then the judge says, okay, I'll take it under advisement, or makes a ruling. Here the judge is going back and forth. I used to love it this way because I think it's so much easier to get to the heart of the issue, make your arguments under this type of format. What do you think?
So it's a gift for both sides because the judge is giving them the opportunity to address both her concerns, her questions, and look, And look, it's much better to know what a judge is thinking when they ask counter questions to you than when you just make an argument for 20 minutes, Michael, and you know this, and you're like, I don't know what the judge is thinking or what she isn't thinking. She is countering some of his arguments. She's saying, well, how do you address this or how do you address that? And that is a good thing. And the good thing for both sides is by her doing that, the record's going to be clean. There won't be confusion about what was addressed in the hearing. And look, a good capital defense attorney is going to want to protect the record. So kudos to the judge and kudos to them for getting this kind of a hearing. And I agree with you 100%. This is always more preferable than just kind of willy-nilly arguing and hoping for the best.
Yeah, and it's more fun to watch and absolutely more fun to participate in. All right, Franz Burkhardt, thank you so much for joining me on this Friday. As always, my friend, you have a fantastic weekend. Folks, I want you to stick around, though. Coming up next in our next hour, our coverage continues in the pretrial hearing of accused killer Brian Walsh. The prosecution lays out...
Ana Walsh's argument is, with the guest being there, Mr. Walsh used the guest's presence to create a facade of a jovial, happy couple having a New Year's Eve celebration.
The prosecution lays out its argument against dismissing those first-degree murder charges against Walsh for allegedly killing and dismembering his wife. And it was sentencing day for convicted murderer Lori Daybell in her conspiracy cases. Crime and Justice correspondent Matt Johnson is going to join us with a live update. So keep it here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Michael Ayala. A jury found Lori Daybell guilty of conspiracy in the murder of her fourth husband, Charles Vallow, back in April. And then last month, another jury convicted her of conspiracy in the attempted murder of her niece's ex-husband, Brandon Boudreaux. Well, today, at her sentencing hearing, Daybell refused to take any responsibility for her two Arizona convictions. Court TV Crime and Justice correspondent Matt Johnson joins us now live with a debrief.
Doomsday cult mom Lori Vallow Daybell defiant and showing no remorse for any of her crimes here in Arizona earlier today.
Heaven is a very busy and happy place where everyone is engaged in projects that they love to do. That includes Joshua, that includes Tylee, that includes Tammy, that includes Charles. No one there, none of these people are seeking revenge or justice. So although we miss our loved ones, and I do too, I assure you that they are busy and happy and peaceful. I have felt the kind of contentment that they feel now, and I try to duplicate that here.
Lori Vallow Daybell in an Arizona courtroom taking no responsibility for the murders of her children, JJ and Tylee, and her fourth husband, Charles Vallow, or her current husband's wife, Tammy Daybell, or the attempted murder of her niece's ex-husband, Brandon Boudreaux. Instead, the pro se defendant appeared defiant and dismissive in the Arizona courtroom during emotional victim impact statements like this.
The truth doesn't lie, Lori, and now the truth has destroyed you. Lori, you have noticed this courtroom is full. It's not because people admire you. It's not because they see instrument in God's hands. It's because you're a sideshow freak, a murderous carnival act. People come to gawk at the monster who thinks she's divine. They don't come to honor you. They come to witness the wreckage of your delusion and to see justice crush it. You've always wanted an audience, but this audience isn't here to adore you. They are here to watch you fall, to watch you stripped of the spotlight you crave, to see your false crown ripped away. You are not a goddess. You are not chosen. You are not powerful. You just thought you could play God and win.
People in the gallery were wiping away tears during statements from Charles Vallow's sister, Kay Woodcock, and the surviving victim in all of this, Brandon Boudreau. Take a listen to his statement.
Lori Daybell, someone I considered family, conspired with others to shoot at me. An act that not only endangered my life, but it threatened to destroy the sacred family unit that I cherish. The betrayal by someone connected to my family has left me battling overwhelming emotions over the years. I lived with constant vigilance, loneliness, regret, sadness, depression, anger, heartache, and embarrassment, all whilst dying.
The gallery was full of law enforcement, media, and trial watchers from across the country who waited in long lines for several hours just to get a seat in court. After the sentencing, the courtroom was cleared very quickly after someone shouted this at Cult Mom. Listen.
Lori, right in prison. We can't do that. Let's go. Everyone out now.
The Doomsday Cult Mom winking as she left that Arizona courtroom earlier today, now sentenced to a total of 7 life sentences behind bars. Before she serves any time here, however, she'll be shipped back to Idaho. Michael.
All right, Matt Johnson, thank you so much for that report. Appreciate it, as always. Folks, I want to turn now back to Massachusetts, where defendant Brian Walsh returned to court for a pretrial hearing seeking to have first-degree murder charges against him dismissed. Now, Walsh is charged with murdering his wife, Ana, and disposing of her body, which has yet to be found. Walsh's attorney claims the evidence presented to the grand jury does not support a charge of first-degree murder. He argues there's no evidence of premeditation or extreme cruelty as required by Massachusetts law. Now, the Commonwealth counters that there's ample evidence showing that Walsh was aware of his wife's affair and that it was the motive for murder. Walsh is also seeking to get information related to the federal investigation into former trooper Michael Proctor. Remember, Proctor was the lead investigator in Karen Reed's case who came under fire for possible bias. Well, he was also the lead investigator in Walsh's case. All right, let's head back to court now for this hearing, and let's hear a little bit more about the defense's motion to dismiss.
There was reference to the federal case.
There's reference to the federal case. I was just wondering whether there's any evidence of payment in that docket, because if there was evidence of payment in the docket, then it would be fair to say that they had evidence before them. Often, in my experience, when restitution is paid, it may not have happened here because the sentence doesn't happen until 2024. But that would have been certainly something that would have been noted. And they did get darn close, it looks like, from my recollection of my review of that docket to a sentencing. But then I don't know what happened, but they retreated.
So if the grand jury
so they do have evidence in his statements that some restitution was paid.
And they did not hear any evidence that there was some conflict about, or some argument about the amount of money that had to be paid back. There's nothing like that presented to the grand jury. There was the stresses revolved around primarily the 3 children in the DC. And once again, AK testified about the plans that both Brian and Ana Walshe were trying to make to move the 3 kids up to DC. So what you have is testimony of stresses in a family grounded in what we'd all believe would be true. 3 young children living in one place, mother living in another, and they're trying to work this out, and it's taking longer than expected. How does that become a reasonable, articulable, and trustworthy fact to build a premise that stress led to premeditated murder or malice in any of its forms? It's pure conjecture, it's speculation, and it can't be the basis for this indictment. I don't want to keep going on here. I would like just to make clear something here before I sit down. and you can shut me down, Judge, I know you will if you want to, but it is this Riley thing. And let me just say briefly, I would be happy.
I won't shut you down because I'm not sure, I'm still not convinced that it's relevant to the decision I need to make on this motion, but
okay,
it's certainly going to be relevant later, so that the earlier I get educated, the better.
So let me try to make, let me try to make the argument that it is relevant.
Okay.
Because we do argue it. What we're saying basically is that the grand jury has to hear the elements of the offenses that are encapsulated in 265.1 statutory language. It's not, there's two separate bodies of law. 265.1, that covers all the theories, but that is a procedural issue. It's a little substantive, but it's procedural. Over here, we have all the case law, Moran, Walsh, and I believe, the way I interpret Riley, to say this. You have to present the elements. And for some reason, the way the justice wrote that opinion in Riley was, we want to clarify what we left open in DePace. He doesn't talk about Moran or anything. And what I think he's clarifying is, let's just be clear. In DePace, we talked about 265.1 because the challenge was on the face of the indictment. In Riley, we're talking about something else. We're talking about what the grand jury heard. And so under Moran, if the grand jury does not hear sufficient evidence of the elements of a particular theory of murder, then the indictment, as we're asking, that so much of the indictment that can be read to include, in this case, extreme atrocity, and they didn't argue felony murder, so I'm not going to waste the court's time on that, but extreme atrocity, you can't try him on extreme atrocity because the indictment doesn't include it.
See, we're ending at the same place. To me, you're seeking to limit the Commonwealth with regard to the theories it may pursue at trial based on a failing in your perceived failing of proof in the grand jury. It seems to me that's not a dismissal of the indictment for first-degree murder. It's a motion in limine to say that the Commonwealth can't have that evidence at trial. Even if I credited your world view with regard to that case law, that alone wouldn't result in the dismissal of the indictment because of the evidence, if I credited it, of premeditation, right? That's why I see this slightly differently than you do.
Well, and I would agree with you, Judge. If you found sufficient evidence to the grand jury of premeditation and the type of malice that only applies to premeditated murder, if you find that, I agree they can. So much of the indictment that charges first-degree premeditated murder stands. But it's due process that requires this court to consider whether that indictment that was issued under the language of 265.1 encompasses extreme atrocity and cruelty, and for that matter, felony murder. And why? Because we have to be able to prepare our defense, and we have to know what the Commonwealth is going to charge, because that's the other part of this due process argument. We have to be prepared to challenge the extreme proof of extreme atrocity and cruelty, and they can't present it because the grand jury didn't hear it.
If my ruling it ends up that the murder charge isn't dismissed, you have plenty of time. You don't have to wait on your motions in limine. You will have plenty of time to brief and address that issue between now and October. I mean, it's plain to anybody in this courtroom that knows the evidence in this case that whatever the Commonwealth's evidence is with regard to cruel and atrocious behavior, certainly isn't their lead argument. It's not great.
Well,
I mean, it'll be even if I allowed it. Frankly, this is where I go off script, and it's never good. Even if I allowed your motion or I denied your motion and said, "Oh no, they can go forward on both theories," as a strategic matter, they got to start thinking, "Are we shooting ourselves in the foot by doing so?" Because from what I've seen, it's pretty thin.
I appreciate that comment, Judge. I understand you're not making a ruling, but I appreciate the comment. But I'm not going to.
But I get it. You have to get ready for trial in both theories.
And I'm going to infuriate Assistant District Attorney Cusick when I say this. I'm going to stop beating this dead horse. You and I, and Attorney Porges on behalf of Walsh, I don't think I'm making myself clear about the differences between what you're suggesting, a motion in limine to kick out a theory of first-degree murder, and what we're asking for the court to do.
You're asking me, I know what you're saying, you're asking me to dismiss it in so much as it charges cruel and atrocious.
Yeah, yes.
I understand what you're asking for. I'm not even sure, well, I'll look at your cases. I'm not even sure I've seen that ever done. It's an interesting concept, and I'll give some more thought to that if I get there. Maybe the Commonwealth will make our job easier.
It looks like they've made our job easier for felony murder. They didn't even brief it.
Right, well, we gotta start, I mean, October, tick-tock, coming. So figure out what your theories are gonna be, and let's argue about the things that really matter, right?
Well, these really matter to us.
I
understand.
And I don't take any of this lightly. And when I say, let's talk about the things that matter, if it is the case that the Commonwealth's not going to really pursue cruel and atrocious, then we're just wasting our time, right?
May I have a brief moment to ask a question?
Certainly.
All right, so it's not all bad for the defense. A bit of a mixed bag there. The judge seems to agree on some points, not so much on the others. Not sure he's going to get it dismissed, though, but we'll have more of that pretrial hearing in the dismembered wife murder case against Brian Walsh straight ahead. Plus, we're also going to take you to Florida for a look at some of the closing arguments in the penalty phase for quadruple murderer Shelby Neely. So keep it here on your front row seat to justice.
Tonight on Closing Arguments, Shonda Vander Ark coming back to court asking for a new trial in the torture and murder of her son with special needs. We're live with key takeaways from today's hearing.
Closing Arguments tonight at 8/7 Central, only on Court TV. Next week.
Join us each morning to get trial ready for the day's proceeding. Plus, deeper dives into true crime stories with our daily spotlight.
Opening statements with Julie Grant. Mornings starting at 8/7 Central on Court TV.
Folks, we're going to get you back inside the courtroom in just a moment. But first, let's bring in our guest for this hour. Joining us, criminal defense attorney, former assistant district attorney, Marie Pereira. Marie, great to see you. Thank you so much for joining me on this Friday. And as we were going to break, I mentioned it seemed like a bit of a mixed bag for the defense. They're asking the judge for certain things. I don't think they're going to get the dismissal on that first-degree murder charge, but she's given them some fodder to deal with. And it sounds like they have some decent arguments to argue to the jury, at least, at trial.
You know, they do have some decent arguments, but it sounds a little bit convoluted. Listen, Mike, zealous advocacy always begins pre-trial and continues during trial. So I can't fault him for trying to get the judge to throw out some aspects of the grand jury indictment, but that's not really going to happen. I think I agree with you when you say that, because the bar is so low for an indictment, it's probable cause, more likely than not. And anything you disagree with post-indictment, you should argue during the trial. So I don't think the judge is going to throw out those aspects that he's not happy with to basically take this case away. I don't think the judge is going to create case law on this case for him.
Yeah, no doubt about it. But you got to remember, this is a first-degree murder case in Florida, which means what? The death penalty is on the table. So really anything that you can do from day one to create options or opportunities for appeal, et cetera, or get the death penalty off the table, you got to take them if you're representing Brian Walsh.
Well, absolutely. It is zealous advocacy. And it sometimes it even begins during the police investigation and before an arrest. So I don't blame him, because you're right, there is a lot at stake here, but I don't think the judge is going to create new case law. And the judge is already saying, I hear you, but I've never seen that done before. What you're asking for is not typical. That tells me I'm not about to create new case law for you, bro. That's not going to happen.
Yeah, without question. And finally, quickly, what do you think about the way this hearing is playing out? The way the judge is going about it, because I mentioned this earlier, a lot of times in these hearings, what you get is you get two attorneys making arguments. The judge says, thank you, I'll take it under advisement, makes a ruling. Here she's kind of going back and forth with the attorneys as if it's some sort of appeal. And I just love it. This was always my favorite way of going about these things, because you get to know what they're thinking. You get to argue right then and there some of the issues that the judge may have.
I think the judge is being very fair about it. And she's even admitting, you know what? I've never seen this requested before. Tell me everything now so I have a clear understanding of what I'm about to make a decision on. Tell me what your concerns are. Because I think she wants to be fair, she wants to be impartial, and she wants to be well informed. So she's giving this person who's making the request, the defense attorney, an opportunity to really speak to what is the rationale behind the request so that she understands when she makes her decision whether or not to grant this motion in limine.
Yeah, and if I had to guess, it looks like they have some kind of relationship. By that, I mean, he looks like he has appeared in front of her before because they have sort of a relationship, and that always helps at the end of the day. All right, Marie, stand by. I want to go back to court now. We're watching again the pretrial hearing that played out in Massachusetts for Brian Walsh, and this was yesterday. Well, now the judge is hearing the Commonwealth's argument as to why first-degree murder charges should not be dismissed. Let's listen in.
Good morning, Your Honor.
Good morning.
Your Honor, the Commonwealth disagrees with Mr. Tipton's interpretation of the Riley case. Obviously, the court has it and will interpret it as the court deems appropriate. But I would suggest here that the court should not eliminate any theory of first-degree murder, because here the grand jury did have probable cause to find that the defendant committed a premeditated murder with the intent to kill. A few housekeeping matters. The Commonwealth agreed. We're not saying that we thought Mr. Walsh, or there was evidence before the grand jury that Mr. Walsh invited the New Year's Eve guest. That was Ana who invited him. The Commonwealth's argument is, with the guest being there, Mr. Walsh used the guest's presence to create a facade of a jovial, happy couple having a New Year's Eve celebration. And I suggest that that is also borne out by the fact that when Mr. Walsh eventually got in touch with the New Year's Eve guest, I think it was on January 4th, he was asked by the New Year's Eve guest, GM, well, did you argue? And Mr. Walsh's response was, you saw us. Did it look like we argued? So I would suggest that that certainly supports that that dinner was used as a charade. Your Honor, the defendant had serious financial, legal, and marital problems in December of 2022. There was ample evidence that he was aware of Ana Walsh's relationship with a man in D.C. He's certainly doing those searches on Christmas Day. That's the day Ana had said she had to work. Mr. Walsh said that in one of the interviews with the police that she wasn't home on Christmas Eve because she had to work. And there was certainly she did show up late. The flight had been canceled. She did drive up, and that's the night he begins searching WF's name online. Then later on December 27th, he's doing a search about divorce and states to get divorced in, and the results of that search shows that Massachusetts is not a favorable state for divorce. And then the mother hires the private investigator in D.C. Now, the mother says she got the name from Mr. Walsh, that he told her not to do it, but I would suggest here he gives her the name of a private investigator. She hires the private investigator to investigate whether Ana is engaged in activities that are not appropriate for a married woman. And certainly I understand the court's question about the timing of those voicemails. I don't know off the top of my head the voicemails from the mother to the investigator firm, but we will look into that and see if there is anything in it.
The one that I'm most interested in is, well, I'm interested in whether there's a timestamp on any of them, but the one that I'm most interested in is file 046. And in that message, she indicates, my son says, could you please check WF? because during that period he was in Idaho and he just wants to see how often they saw each other. That's the one that I want to know, that whether the evidence was before the grand jury as to what the time frame of that was.
Certainly, Your Honor. We will re-examine the exhibits, and we'll let the court know, and we'll let counsel know, obviously, what we decipher, whether the timestamp is indeed in front of them or whether it was not. Your Honor, here the grand jury also had information from the testimony of AK about her conversation with Ana on December 29th, I believe. They went out to dinner, and she describes Ana as just being beside herself. Ana described a huge fight with the defendant over Christmas, had given him an ultimatum about the children coming to D.C. to live with her. She had found out that the defendant, and she does mention the lawyer also, but essentially that the defendant had engineered the children remaining in Cohasset with him because it was perceived that that would help him avoid an incarcerated sentence on his federal case. Certainly there's discussion of that during the interview with the one where the lawyer was present at, and he makes a remark about which one could infer means essentially, well, if Ana's not around, that's off the table of me going to jail. But certainly recent news to the defendant and to Ana as related through various conversations that suddenly the topic of him going to jail had arisen, and that according to AK, Ana had said he should just do whatever is necessary to resolve this, even if it involves an incarcerated sentence. So I suggest that is another, we could characterize it as a stressor, but it's also another reason why if Ana's not around, if Ana is deceased or disappeared, the defendant would suddenly be a single parent, would have the children's sole caretaking for these 3 small children. He would potentially avoid that committed sentence, which he was very motivated, one could infer from the materials before the grand jury in avoiding. He would inherit millions of dollars in life insurance proceeds from Ana. Again, those searches also include some searches for luxury items. One could infer that he's planning to, how he might spend those proceeds. And he would also...
But those searches, I don't think that rings true, because those searches with regard to in terms of premeditation anyway, the searches with regard to the watch are later.
I agree with that, Your Honor. I just suggest that...
So how does that relate to premeditation?
Your Honor, I suggest it relates to the concept of having money, which was certainly a stressor, that the defendant needed money to pay that restitution. I know at some point, I believe it was in the interview with the lawyer, forgive me if I'm mistaken, but I think it was he owed $450,000 in federal restitution. And I suggest here, the fact that he is looking at luxury goods suggests that this is, again, expecting to inherit money. Some of the searches are for cleaning up crime scenes. Specifically, I suggest that shows that the defendant's awareness that this was indeed a crime and not some sort of accidental person dying in a home.